Gini. Itu kan grup kelas, grup pidana. Itu dia tadi linknya. Begini coy. Orang Singapura online coy. Sistem hybrid.
Suara mobil.
Good morning, Professor Chen.
Good morning. Good morning.
We wait for 1 minute, then we will start the class.
Okay, thank you.
Thank you.
Oh, udah. Apa namanya? Apa namanya? Nama apa? Nim. Nim. Nim jangan lupa.
Anjir.
Okay, good morning, class. We will start our class. First of all, I would like to say thank you to Professor Chen Siyuan from SMU, Singapore Management University School of Law, who feel free to join us, and we are very welcome you, Prof. I would like to introduce Ms. Rafiqoh Lubis. Ms. Rafiqoh is the team teaching here. She is the coordinator for this class. I hope we will do a collaboration for the future. So, Professor Chen, we have 100 minutes to conduct this class, and the floor goes to you, Prof. Thank you.
Well, thank you very much for the introduction, and of course, thank you very much for the invitation to give this lesson. So as you can see from the slide, today's lesson is about the criminal case investigation process. And because I'm from Singapore, I'm going to talk about things that are a bit more related to the common law system, which is what Singapore adopts. So before I begin, maybe I'll just briefly introduce myself. I've been teaching evidence law and procedural law in Singapore for around 15 years. I also have a side practice whereby I'm a consultant, whether it's for criminal defense lawyers or for NGOs that need help with matters relating to evidence law and procedural law. And in SMU, I also run the moot court program. So much of what I do is related to courtroom proceedings, especially in criminal cases. Okay, so with that out of the way, I think it's important to understand how a common law system like Singapore operates in terms of what exactly is a source of law. Unlike many civil law systems, for Singapore, cases are usually the first thing that the courts would refer to when trying to decide how to interpret or how to even find a rule or regulation. And stare decisis, as you might know, refers to this idea that the higher the level of the court, the more it binds the lower courts. So in Singapore, we have the state courts, which are where most of the trials take place. And those can be appealed to the High Court, which is the second highest court. And then our highest court is the Court of Appeal. So we don't have that many tiers. And we also don't have separate courts that deal with, say, for instance, we don't have a constitutional court that deals with matters relating to interpreting the Constitution. So generally, whatever the Court of Appeal decides, the other courts have to follow in some way. Of course, sometimes they may interpret what the Court of Appeal has said in a different way, But generally, that's how it works. It's a vertical stare decisis. So Court of Appeal decides, everyone follows. If Court of Appeal hasn't said anything about it, then we look at whether the High Court has said anything about it. And if the High Court hasn't said anything about it, then I suppose there is no binding precedent, right? The state courts and the courts can do whatever they wish. So it's not as though Singapore does not have statutes. We do codify some laws. So in today's lesson, we are really looking at criminal procedure and criminal law. So generally in Singapore, anything that's related to criminal law, including criminal procedure, will be codified. So we do have statutes for that. So I'm not an expert in civil law systems, but having looked at a few civil law codes, the way common law systems codify their laws are a little different. So my understanding is that in civil law systems, you could have rules that are expressed in fairly general terms, right? But in common law systems, especially when it comes to criminal procedure, the rules are quite detailed, right? So they try to imagine as many situations as possible, and they try to write it out in a code. And what this means is that in Singapore, I've already mentioned that we have a three-tier court system, right? The state court, the High Court, and the Court of Appeal. But what happens if you have a statute? What happens if you have a codified law? So in Singapore, the highest law of the land is the Constitution. I think that's probably the same in many parts of the world. But what comes after the Constitution would be your statutes. Okay, so even the Court of Appeal, which is the higher court, they cannot ignore the statute because the statute is a higher source of law after the Constitution. Okay, so Constitution, statute, common law. What about, so common law meaning cases decided by the courts. But what about subsidiary legislation? Because in Singapore, statutes are passed by Parliament. Okay, so they are supposed to represent the will of the people. It's a very democratic thing, in other words. But what about subsidiary legislation, which are not really passed by Parliament, but are documents that are, in a sense, created by the executive to clarify, what other rules might apply. So it's a bit unclear in terms of whether or not the court can, for example, is it a higher source of law than subsidiary legislation? But I think in practice, generally, even if it's subsidiary legislation, the courts, including the Court of Appeal, would follow what the written laws say. And if it's not even a subsidiary legislation, it's just a soft law instrument. So for instance, maybe the police, they have their own internal regulations, which are not law creating in character. That one, less likely the courts will follow, but the courts may refer to those things. Now, what about academics? Are they a source of law? So such as myself. So in the common law world, and certainly in Singapore, academic writings may be referred to, but not all the time. In fact, I would say not that often, right? Of course, if an academic has written a very influential text or article, then that may be referred to more often than the usual. But generally, the courts would still look at, if there's a statute, they look at the statute first. Of course, if there's a constitutional right, they have to refer to the Constitution. But in Singapore, that's not very often. So usually it's statute if there's a statute, and then case law, but based on stare decisis, right? Is there a Court of Appeal case? Is there a High Court case? And if really all of those things don't give an answer, right? The Constitution doesn't give an answer. The statutes don't give an answer. The case law don't give an answer. That is when maybe the Singapore courts might look at academics. Finally, in terms of cases from other jurisdictions. So for instance, would Singapore look at English case law? Singapore, as you might know, was a former colony of England, and we did inherit many laws from England. But ever since around the mid-1990s, we have been slowly moving away from what English law has to tell us. So we don't reject it completely, but the whole point is that in the last 20, 30 years, we've been trying to create our own rules that are better suited to our own system, Okay, so and it's not just England. Sometimes we also refer to Australian cases or Indian cases, because for our criminal laws, whether it's the Penal Code or the Criminal Procedure Code, we took that from India. And to be even more specific, the English gave the laws to the Indian states, and then we took it from the Indian states. But again, I think more broadly, we try to interpret our laws in a way that is more suitable to our own context, especially when it comes to public law such as criminal law or criminal procedural law. For private law such as contract law or arbitration, I think there are other considerations at play, because Singapore, when it comes to commercial litigation or commercial laws, I think it tends to be in Singapore's strategic interest to align ourselves, right, with what is going on with the rest of the commercial world. So that's for sources of law. Other features of the common law system are worth pointing out, especially in the light of today's topic. One feature of a common law system is that if you have a bad lawyer, you may have a pretty bad case. Because as you'll see later on, the courts, the judges are supposed to play a limited role. And this will also affect the criminal justice process in some way, right? So in a criminal case, of course, the lawyer for the state will be what we call the prosecutor. And the lawyer for the accused person will be called the defense counsel. But quite often, especially in not so serious crimes, the accused persons may not have the means to get legal representation. So that it's entirely possible that they go to court unrepresented. And because it's an adversarial system, which is to say that the court, as far as possible, they leave it to the parties to fight it out, right? The court is a bit like an umpire in a sporting match, right? So a referee in a football match, a referee in a basketball match, the referee is not going to help either team, right? The referee is just there to decide if the rules are broken and how to interpret the rules. So likewise, in the adversarial system, that's how it works. So imagine if you send a football team, but you don't really have that many players, right? It's the same idea. You're not going to do as well as you might want to. But when it comes to the more serious crimes, so for example, if it's murder, if an accused person has been charged with murder, which in Singapore could carry the death penalty, the state will assign a lawyer. Okay, and these lawyers, they generally work almost pro bono, but not totally pro bono, so they're given some money. But even then, you can't choose your lawyer, right? You're given whichever lawyer is assigned to you. So as I mentioned, in a common law system, the judges play a more passive role, right? So for instance, they will not what we call descend into the arena, which is to say, they will not start taking over the role of either the prosecutor or the role of an accused person, right? It's entirely possible to sit through a criminal trial in Singapore in which the judge doesn't say much. Sometimes the judge may direct the witnesses to perhaps answer questions more directly, or may direct the lawyers to get to the point a little faster. But when it comes to cross-examination, the judges try not to interfere too much. And in a common law system like Singapore, cross-examination is considered extremely important. And what happens in cross-examination? There's really one main objective when it comes to cross-examination, and that is to undermine the credibility of the person that you're cross-examining as much as possible. So imagine if you have the crime is that of rape, right? Let's say a person has been accused of raping somebody, and defense counsel, what would be the main strategy? It's a bit unfortunate, but this is what the strategy would look like. In all likelihood, the defense counsel would, if possible, undermine the credibility of the complainant during cross-examination. So defense counsel will try to ask questions to review any sort of inconsistencies that the complainant may have. Right. So, for example, if the complainant says that on this day, at this time, this is what happened, defense counsel would try to poke holes in that theory, because in a criminal justice system like Singapore's, the idea is not really to show that the accused did not commit a crime. I mean, that could be part of the objective, but primarily you want to show that the case cannot be proven beyond a reasonable doubt, which is different from being absolutely sure. And not only would the court be very reluctant to be involved in the cross-examination of witnesses, the court is also very unlikely to be involved in evidence gathering. So in other words, let's say in the rape case, again, what sort of evidence might you be looking at? I've already talked about how there might be testimony from the complainant. The accused might testify, but that's rare. Then what else are we left with? Because in a crime like rape, there are usually no witnesses, right? It's done in a sense secretly in a place whereby no one can see or tell. So what other evidence might there be? You might have your medical records if the complainant went to the hospital or a medical professional. You might have psychiatric records if the victim was interviewed by any psychiatrist or psychologist. You might have alibi witnesses. So maybe the accused is able to say that, oh, someone can confirm to the court that I could not have been at this place at this time. So on and so forth. So the court doesn't tell either party to go and find this evidence. What happens is that all of this evidence should have been gathered by the prosecution and the defense counsel before trial starts. And if it turns out that the prosecution did not gather enough evidence or did not look into certain things, the court is not going to do it for either party. The court might in some cases, the court may say, okay, there are certain things that are missing. Can you go and find them? That's possible, but the court will not be directly involved. So the court doesn't investigate the crime. It's really the prosecutor working together with the police, right? And as for defense counsel, well, we'll come to that later, but generally, they don't have the same access to evidence as the prosecution would. Another feature of our criminal justice system is that we no longer have trial by jury. So jury trial in some jurisdictions, such as in the US, they see it as emblematic of democracy because you're essentially, the pronouncement of guilt is rendered by basically other members of the public. So they see that as being very important for a healthy democracy. But in Singapore, we abolished jury trial, I think almost 40, 50 years ago. And the thinking is that, at least for our previous prime minister, his thinking was jury trials are easier to mislead, right? Members of the jury are easier to mislead than, say, a judge. So what that means is that in Singapore, the fact-finding is done by the judge. And the determination of the law is also done by the same judge. So there wouldn't be that jury that you need to convince in terms of trying to establish the facts. Everything is going to be based on the judge. And why is this important? It's important in two ways. One, this discourages any sort of storytelling. You know, when you watch TV, especially TV relating to Western legal dramas, you'll find that there's always some impressive opening statement or closing statement by the defense counsel to members of the jury, right? They're trying to tell a story. That wouldn't work as effectively if you're trying to tell a story to a judge who is legally trained and who is so experienced in deciding criminal trials. So this is not to say that a judge is necessarily better, but just that the judge is less likely to be impressed because he or she will be so used to criminal proceedings. The second difference, I suppose, is that because the judge is legally trained and have many years of experience, the judge is more likely to rely on ideas of discretion as opposed to the rules. And we see that a lot when it comes to matters relating to evidence. So what do I mean by that? If, let's say, the dispute in the Singapore courts is a contractual dispute or tort law dispute or criminal law dispute, in figuring out what the law is, as mentioned earlier, the courts will look at the usual sources of law. You look at whether the Constitution applies, whether there's any relevant statute. And if none of those apply, then they look at, okay, what do the case law say? And if the case law says certain things, they would tend to follow the case law. They wouldn't say, oh, yeah, I know that this case exists, but I'm not going to care about it. It's very unlikely when it comes to substantive areas of law. So contract law, tort law, criminal law, administrative law. They will follow the rules. But when it comes to evidence, when it comes to procedure, even though there are statutes for those, quite often the court will take a more flexible approach. Right? It's not unusual in the Singapore courts to look at a statute and say that for criminal law, for criminal procedure, not criminal law, for criminal procedure and criminal evidence law, and the courts will conclude, you know what, we can just exercise our discretion and we will just decide in our own way, even though there's a statute for it. Okay, what other consequence is there working within a common law system? If there are findings of fact that are made by a trial judge, when it comes on appeal, it's very unlikely that the appellate court will interfere with the findings of fact made by the trial judge. Okay, so again, if you do not have a good lawyer at trial, that lawyer is not able to really bring forth the best evidence for you. The lawyer is not very good at raising doubts about the other side's case. Then those findings of fact would certainly tend to be a bit more in favor of the opponent. And that can't be changed by the appellate court. So you really need a good lawyer, or at least a pretty good one, right? If you want to have a good chance of doing well. And of course, this raises questions about access to justice, right? Because why should justice be dependent on who you can afford to hire? But that's something that I think the Singapore legal system is trying to gradually change. So for example, they try to make some of the rules easier to understand. There's now also a public defender's office, which is to say that even if you can't show that you completely can't afford a lawyer, there might still be ways to get you legal representation. Okay, so I already mentioned this point about discretion, which is for evidence and procedural law, as a matter of practice, the judges in our courts like to exercise discretion. And it's not that clear. It's not that clear in the written law, in the statutes, that the courts actually have that much discretion. But as a matter of practice, that's how they look at evidence and procedural law. It's more flexible than substantive law. And finally, what do I mean by this point? Not all branches of governments are co-equal. So I'm referring to Singapore, of course, not the whole world. In Singapore, in theory, we subscribe to the idea of the three branches of government. So the judiciary, which will be the courts, that's one branch. Then we have the legislature, which would really be parliament. And then we have the executive, which would be the different ministries that carry out the law. So that would include, for example, the Attorney General's chambers, which is where the public prosecutors work. But when I say not all branches of the government are co-equal, Singapore is often described as having some supremacy vested in the legislature. So in other words, Parliament, right? Parliament sits on a slightly higher plane than, say, the judiciary or the executive. And that conclusion is reached by virtue of the fact that it is Parliament that represents the will of the people, because Parliament comprises your members of Parliament who are voted in by the people, and they come up with written laws that will bind the courts. So in that sense, Parliament is supreme, right? And Parliament also has the power, although they have to achieve a 2/3 majority, to rewrite the constitution or to amend the constitution, which in Singapore, they have done so quite a few times. Okay. Now, I will be brief on this slide because I really want to get into the details of our system. But I think it's also important to be apprised of the following points. So in Singapore, you might know this, we have a reputation for being tough on crime. right? We have a few slogans that our police have tried to imbue into the public consciousness over the years. One of which would be low crime doesn't mean no crime. So just because there aren't that many crimes doesn't mean there are no crimes, right? So I think as a and this is something that I suppose many members of the Singapore public embrace, right? If you were to give them a choice, would you prefer to have more protections for accused persons, but as a result, having less of them, fewer of them convicted? I think a good number would say, if our laws are very strict and not very friendly for the accused, but that means that there's greater safety for the people, I think many people would say we will choose safety. And this is not just a very nebulous philosophy. I think there are very tangible expressions of this philosophy, a preference of crime control over due process. Now, of course, if you have ever read in this area, you would know that many academics dispute this dichotomy. They don't think that greater crime control must necessarily result in lower due process, but I think it's a dichotomy that generally does exist. So what are the tangible expressions of this philosophy? We see that, for example, in how crimes in Singapore are formulated and interpreted by the courts. So I mentioned earlier that much of our criminal law has been inherited from India, and the Indian Penal Code was written, I believe, sometime in the 1800s. So you're looking at almost 200 years ago. 200 years ago, civilization was quite different, right? Whether it's in India or in Singapore or anywhere in the world for the matter. And I would say generally 200 years ago, laws were stricter, okay? But that's just one. Two, in terms of how the laws are interpreted, I think the courts have that choice, right? They can try to give a strict provision, a more liberal, rights-conscious meaning, but they can also choose to give it its original meaning, which may be quite narrow and therefore facilitative of crime control. I'll give you an example. Suppose you have 3 friends who one day decide to rob somebody, and in the process of robbing somebody, one of them kills the victim, right? So they didn't plan to kill the victim. They only plan to rob. So under our penal code, there's this provision that pertains to this idea of common intention. And what common intention allows potentially the court or the prosecutor to do is to say that even though only one of them out of the 3 persons intended to kill, you could catch all 3 of them with the same crime of killing. Okay, now over the years, how this idea has been interpreted by the courts have changed. At its highest level, it was quite easy to catch everybody with this common intention provision, right? There were certain cases decided from the 80s to the early 2000s that facilitated this idea. But over time, I think that idea has been read down. And so now it's not so easy to catch a group of people with just one provision. You might need to independently show that other persons who were involved also had the same intention. So that's for substantive criminal law. But even in procedural law and evidence law, you can see examples of how the system tends to favor crime control rather than due process. We'll look at some of those examples later, but I'll give you an example now. As we often watch on TV, when a person is arrested, what is usually told to the person? What would be one of the first things that you tell a person who's arrested? This is a more Western view. I think generally in Asian jurisdictions, we tell them different things. But when you watch Western TV, they always say you have the right to remain silent, right? There's a right to silence. And of course, the right to silence applies in Asia as well, but to different degrees. And so in Singapore, the right to silence, as we'll see later on, is a very, very differently interpreted. So for sure in Singapore, you cannot keep silent all the way. In fact, if you keep silent, it will start to work against you. It will eventually bite you, right? When trial starts. So it's never really in your interest to keep quiet. And that's because in Singapore, that's how we have formulated our procedural and evidence rules, right? We don't take the view that you're entitled to keep quiet all the way. And if you try to unpack it from a more general level, why should an accused person even be allowed to keep quiet? So from the due process point of view, the accused person should be allowed to keep quiet because the accused person may say something that may hurt his own case, right? And so you want, and coupled with the fact that the accused person is best represented by a lawyer rather than by himself or herself. So you want to protect the accused person in this way, even though this accused person may seem like the worst person on earth. But that's what the law is for, right? Is to apply equally to everybody. And so if you want to make sure that this person doesn't make a mistake at the start, you say he's allowed to keep quiet. But in Singapore, the thinking is a bit different. In fact, fundamentally different. The mentality is, hey, if you didn't commit a crime, why are you keeping quiet? Right? So if you didn't commit a crime in Singapore, you must speak up, or at least you are encouraged to speak up early, because if you only speak up later on, there's a good chance that no one is going to believe you anymore. Okay, so it's a very different approach from much of how the other common law jurisdictions work. Then we have statutory presumptions. What are these? Singapore being tough on crime. If there was one crime that Singapore is the toughest on, it's on drugs, right? And we have the Misuse of Drugs Act, and it has two critical presumptions. So suppose a person travels through Changi Airport, Singapore's airport, and he's arrested. They find drugs on him, say maybe 20 grams of diamorphine, which is a restricted drug in Singapore. Under our Misuse of Drugs Act, two statutory presumptions kick in. One, the person who is caught with those drugs cannot deny that he didn't know what the drugs were. He also cannot deny that he wanted to traffic them. So the prosecution doesn't need to prove this. The prosecution just needs to show that he has drugs, and then it is for the accused person to prove that he did not know that he had those drugs on him, and he did not intend to traffic those drugs. And if the person fails to rebut those presumptions, it's possible he may get a death penalty. Right? It's possible, but I say possible rather than it's a certainty, because there's some discretion to decide what sort of penalty he should get. But the presumptions are there for sure. Okay, so this is another example of how our laws are created to have greater convictions rather than fewer convictions. And of course, I already mentioned that death penalty, right, is part of our suite of laws that attempt to deter people from committing crimes. But even trying to appeal, so let's say you are convicted at trial and you try to appeal to the High Court or the Court of Appeal, it isn't so much the case now, but in the past, so from around the 1980s to early 2000s, the very fact that you appeal after you have been convicted, if you lose, they may increase your sentence. So let's say originally you were sentenced to serve 10 years, you appeal and you fail, they may increase it to 15 years. It's quite rare, but it did happen in the past, okay? Okay, notwithstanding all of this, as much as Singapore is big on crime control and tough on crime, there is still supposed to be a subscription to presumption of innocence. But then there's a question of what does that mean? So interestingly, presumption of innocence has, at least within the common law world, a fairly universal meaning, which is to say that it is for the prosecution to prove a crime beyond a reasonable doubt. So the prosecution needs to gather the evidence, charge the person, and then show in court that based on the evidence, the accused person did commit a crime beyond a reasonable doubt. And actually, that's a very basic meaning of presumption of innocence, right? It sounds like it's more a common law thing. In many jurisdictions, they actually do that. Certainly in international criminal law, there are these ideas as well. And one is therefore tempted to conclude that presumption of innocence is just a very bare and thin concept, right? It doesn't have any extra meaning. So if you go back to the earlier points I just made, how the crimes are formulated, how procedural laws are formulated, how presumptions are formulated, this may not be considered necessarily derogations from the presumption of innocence, because presumption of innocence only has a very basic and bare meaning, which is that as a matter of burden of proof, it's on the prosecution. As a matter of standard of proof, it is beyond a reasonable doubt, and that's it. Okay, so now let's look at some of the ways in which evidence may be gathered to prove a crime. I'll start first with the investigation statement or long statement. And this is governed by Section 22 of Singapore's Criminal Procedure Code. So you can Google it and you can read for yourself if you want to, right? It's freely accessible. An investigation statement or long statement can be taken at any time. So before a person has been charged with a crime, and also after a person has been charged with a crime. We will examine the consequence of this in a bit. A long statement can also be taken from both an accused or a witness. So it doesn't necessarily have to be the accused. It can be from any person who has witnessed a crime. And because the statement can be taken before or after, because the statement can be taken more than once, there is a higher chance of contradiction. What do I mean by that? Previously, I mentioned that cross-examination is very important in a common law system, right? Because the judge is not going to ask questions. It's either the prosecution or the counsel for the defense or accused. When the prosecution has multiple statements from the same person, there is a higher chance that that same person didn't tell the same story in all the different statements. And when that happens, the prosecution raises this to cross-examination, the person who has made contradictory statements is less likely to be believed by the courts. So I think this is another example of crime control in action. Not only that, a copy of the long statement may not necessarily be given to the accused. Why is this important? Keep in mind that when a person has been arrested for a crime, that person is likely to be interrogated by the police. That person is likely to be in a state of anxiety, maybe fear. And so when that person has been giving multiple statements over a few days, for instance, what are the odds that the person can remember exactly what was said in those statements? Probably not very good odds. That's just human nature, right? But what would be the other perspective be? The other perspective would be that if you are truly innocent, you won't forget the facts. If you are truly innocent, you're not going to give different stories. But I think that is of course, that's really crime control talking, right? In reality, in our day-to-day lives, we don't really remember everything with great precision, even though we may not have done anything wrong. And sometimes even when we do recall, we may not always recount them in exactly the same way each time we talk about those things. And so when the accused is not given a copy of a long statement or any long statement that he or she has given, not only may this be used against the accused later on at trial, it's also difficult for the accused to prepare a defense. Because if you don't even know exactly what you said to the police, how are you going to prepare for cross-examination? How are you going to prepare your defense? But note that I say a copy may not necessarily be given. So that means that it's possible that it may be given. So in Singapore, we have disclosure laws, which means that before the trial starts, the prosecution and the defense they may need to exchange evidence. So whatever the prosecution is likely to use at trial, prosecution may need to disclose them. And you may ask, okay, so is it optional? You mean the prosecution can refuse? The short answer is that it's not so much that the prosecution can refuse, but it really depends on whether the accused is also willing to exchange evidence. If the accused doesn't file a defense, for example, the prosecution is entitled to withhold more things. That's one. Two, even if the accused does disclose whatever needs to be disclosed that is required under the Criminal Procedure Code or the common law, at the end of the day, it is hard to tell exactly whether the prosecution has disclosed everything. Because the test under the common law is not based on prosecution must disclose everything in its possession. What the law actually states is something more nuanced. And here I'm paraphrasing because the test is a bit more precise, but the idea is that prosecution really only needs to disclose things that are relevant to the trial. But who determines relevance? The prosecution has to first determine it. If the prosecution says that, okay, I don't think this is going to be relevant for either the prosecutor or for defense counsel, I'm not going to disclose it. It's the prosecution's call, right? Now, you may say that, okay, this can be challenged in court, and the court will be the final arbiter as to whether something is relevant. That is, of course, theoretically true. But how will you know that the prosecution is in possession of such evidence to begin with? You probably wouldn't know. And so how are you going to mount the challenge? Because you can't just mount a challenge in the abstract. To mount a challenge, you usually need some evidence to suggest to the court that the prosecution hasn't disclosed enough, right? But because much of the discretion and power is vested in the prosecution, it makes it hard practically to raise such a challenge. Then we have the fact that when a person has been charged, he'll be interrogated, right? We call this the interview or interrogation. It may not be recorded in terms of a video recording. In many common law jurisdictions, this is no longer an issue. Because when imagine this, right? Imagine an accused person is being interrogated by the police, and the police doesn't physically beat up the accused person because that will leave some evidence, right? You will leave injuries and all that. Instead, the police says, if you do not cooperate with us, we will send someone to your home and we will do something to your family. So it's just words. And the accused at trial says, I was threatened by the police. But how is the court supposed to know who's telling the truth? The police would say, no, we said no such thing. And the accused would say, no, you said such a thing. How would the court know who's telling the truth? So actually, this problem can be largely solved. It can't be completely solved, but it can be largely solved by ensuring that any interrogation is properly video recorded. Right? You can set up multiple angles. You can ensure the microphone picks up the audio, no problem. But in Singapore, we've decided that the only time in which a statement, the giving of a statement will be video recorded is when a person is charged with the most serious crimes. And thus far, it's really just one crime in the penal code. I can't remember whether it's murder or rape, might be murder. So outside of those crimes, the statement wouldn't be video recorded. Okay, and that means that evidentially, it's very hard to show that any sort of threat has been made against the accused. But what would the other side say? What would the government apologists say? The government apologists would say that video recording an interview could get in the way of investigations. Right? When you know that you're being video recorded, the sort of things that you would say may not be the same if you were not video recorded. So that's one argument. The other argument, of course, is that, look, you should just trust the police. You should trust the system. So in different places, I think there'll be different degrees of trust. In Singapore, I suppose the trust in the police and the prosecutors is still quite high that we trust them not to abuse the system. But I always think that apart from trusting the system, why not also have safeguards in terms of the rules, right? I think that both of them can coexist at the same time. But the fact that we don't video record interviews to me is another indication that Singapore is definitely still quite entrenched in the crime control model with respect to criminal justice. Having said that, even for a long statement, there are certain procedural requirements to adhere to. So the statement must be in writing. So it can't just be an oral statement. It needs to be reduced into writing. It can be typewritten, that's fine. It needs to be read over to the person who gave the statement. So this is to confirm that these are the things that you said. It must be signed by the person who made the statement. And then there's the final requirement, which can be tricky. And that pertains to interpretation. If the accused, so in Singapore, everything is done in English, even though we have Malays, we have Chinese, we have Indians, and we have an assortment of other people from different places. Everything works in English in Singapore, right? If you want to do business, if you want to go to court, if you want to study, everything is done in English, even if you may speak other languages. But if the accused person does not understand English, then by right, an interpretation needs to be arranged for him or her. The problem is we may not always have interpreters for all sorts of languages. So as I understand it, I don't speak Bahasa, but as I understand it, someone from Indonesia and Malaysia, the Bahasa, there are some differences, right? But let's say if you look at Chinese, the Chinese language, someone who speaks Teochew, which is a Chinese dialect, versus someone who speaks Cantonese, okay, they can probably understand each other a little bit. They won't fully understand each other, but they can understand each other a little bit because there are some similarities in language. But if it's other kinds of Chinese dialects which are a bit more obscure, and there isn't an interpreter to interpret those things into English, that's where you may have a problem. That's where the reliability of the statement may be called into question. But I suppose this is a problem that would exist everywhere. Right? There would definitely, in any jurisdiction, there's no guarantee that you can find someone who can interpret perfectly for the person. But that's where I suppose the court's discretion may come in a good way. So that's for your investigation statement, right? You're trying to gather the facts. So you interrogate witnesses, you interrogate accused persons. But what's interesting about the investigation statement is that under subsection 2 or section 22 of the Criminal Procedure Code, I'll read it out. The person examined is bound to state truly what the person knows, except the person did not say anything that might expose the person to a criminal charge. So earlier I talked about presumption of innocence and the right to silence in Singapore and how that is conceptualized a little differently. And the part that's a bit different is the first half. The person examined is bound to state truly what he or she knows of the facts and circumstances of the case. Could this be a problem? Or is this just sensible and commonsensical? For those who say that it's sensible, the thinking really is, look, a crime has occurred. We need to gather the facts. We recognize that you have a right to keep quiet, so that's why there's a second half, right? The person did not say anything that may expose the person to a criminal charge. That is the right to silence. That's the privilege against self-incrimination. So that's still provided for. But as long as whatever you're saying does not expose you to that, you must tell the truth. Because after all, telling the truth is a good thing for everybody. We want to know who truly committed the crime and who did not commit the crime. But on the other perspective, the idea that a person can be compelled by law to state the truth, I think that's quite unique to Singapore. At least certainly relative to other common law jurisdictions. Right? Because this is definitely not a typical understanding of the right to silence. Right to silence usually just means you're entitled to keep quiet to a large degree. But here you have to state the truth. That's the first point. The second point is, what if the truth potentially overlaps with what might incriminate you? So take, for instance, a person has been accused of outrage of modesty, basically molestation. Imagine a person is traveling on the subway at peak hour traffic. There are tons of people in the train carriage. And suddenly, another person accuses this person of saying, hey, you touched me inappropriately. And the person who has been accused says, oh, did I? I'm sorry, I didn't realize it. It was an accident. But the other person is not satisfied. Said, no, you have committed outrage of modesty, you have molested me. I'm going to call the police. And when the person who has been accused is arrested, looking at this subsection, in his mind, he's thinking, look, I didn't commit anything wrong, right? It was an accident. So what do I say? Do I say that it was an accident, or do I keep quiet? Because if I keep quiet, it sounds like I'm entitled to do so, because if I say anything that relates to a crime, I might be self-incriminating. But at the same time, I'm supposed to state the truth. And the truth is that I didn't commit a crime. So what is the person supposed to do? All right. So now we come then to the idea of adverse inferences, which is related to right to silence. So how right to silence works together with adverse inferences is as such. If you should have said something earlier, but you did not say so, you only say so in court at a later juncture, this is where the court can say, okay, you have changed your mind, and I'm less likely to believe you because I can't trust you. You're telling different stories at different times. Earlier, you said this. Now you're saying a different thing. I can't tell which is correct, so I'm just not going to believe you as much. So that's the effect of an adverse inference. So the question really is, based on subsection 2, can any sort of adverse inference be drawn if a person doesn't state the truth of the facts? That doesn't amount to self-incrimination. And based on Singapore cases, the answer is yes. You can draw adverse inferences even for not disclosing enough at the point of taking a long statement. And what happens if a defense is pleaded at this stage? So earlier I mentioned in the example of alleged outrage of modesty on a crowded subway. And if the person is trying to plead accident, that will be considered a defense. So what have we seen so far? It seems that it doesn't pay to keep quiet. It pays to speak up, right? As early as you can. But the problem with raising a defense at this stage, when you are being interrogated, is that you set yourself up for a harder task down the line. What do I mean by that? So I had mentioned that presumption of innocence means that the prosecution needs to prove a case beyond a reasonable doubt, which also means that for an accused not to be convicted, the accused only needs to raise a reasonable doubt. So no one really knows what reasonable doubt means in mathematical terms. In our common law system in Singapore, there are really only two standards of proof. You can either prove something on a balance of probabilities. In America, I think they call it the preponderance of evidence or something like that, which is to say, as long as the fact finder is more than 50% sure, then the fact finder would believe whoever is trying to prove a certain fact. The other standard that Singapore has is beyond a reasonable doubt. All we know is that it's higher than 50%, but no one really knows what the number is. So some say maybe 70%. The court needs to be 70% sure. And what that means for the accused is that as long as the accused can somehow show that it's less than 70% sure, because there's 30% doubt, then the accused may be acquitted. But if the accused raises a defense, accident, for example, based on the case law, the accused must show that the prosecution is more than 50% wrong, because the accused needs to prove on a balance of probabilities that the defense is made up. So again, if the accused doesn't say anything, to be acquitted, he or she only needs to raise a reasonable doubt, assuming the prosecution can prove the case. But if the accused wants to raise a defense, the accused needs to prove the defense on a balance of probabilities, effectively committing to a higher standard of proof. And so on the one hand, the system expects you and incentivizes you to raise a defense early because of the prospect of adverse inferences down the road. On the other hand, if you do raise a defense, you commit to a higher standard of proof at trial. So again, to me, this seems like crime control in action, right? Because you want to facilitate prosecution and make it hard for accused persons. How about right to counsel? I'm not sure what the situation is like in civil law systems, but in many common law systems, generally speaking, you can get a lawyer quite fast, right? The moment you say you want a lawyer, they're not going to stop you from seeing your lawyer if it's a crime. In Singapore, you will not get to see your lawyer immediately. So the right to counsel is a constitutional right in Singapore. But the way our courts have interpreted it is that just because it's a constitutional right doesn't mean you can exercise it immediately. You need to give the police reasonable time to complete their investigations first. And so that would usually include the taking of the statements, including the long statements from the accused. So how long is reasonable? It depends on the facts. We have cases in which the accused person could not see his lawyer for about 3 weeks. Okay, so in other common law jurisdictions, I think that is, I wouldn't say unthinkable, but certainly very rare, right? But in Singapore, again, I think in pursuit of crime control, the priority is given to the objective of crime control rather than we need to protect the accused. We need to give the accused due process. It's not that the accused can't have a lawyer. It's just that you can't see the lawyer immediately. But what this also means is that the accused will be giving statements to the authorities without lawyer. So on one hand, one could say, okay, this is problematic because the accused might make mistakes. If the accused doesn't know the law, if the accused isn't thinking strategically, the accused might make mistakes, which may then hurt him or her down the line. But the other point of view is, if you're truly innocent, why do you need a lawyer? Why do you need a lawyer if you're truly innocent? Why do you need a lawyer for you to tell the truth to the police? Why do you need a lawyer to point out facts that would exculpate you? Right? So that's why I go back earlier. I said on a more macro level, we need to understand that criminal justice in Singapore is just conceptualized a little differently. Presumption of innocence is modified. Right to counsel is modified in some way. Finally, what happens if the procedural requirements are not met? So in the previous slide, I had said that there are 4 procedural requirements when you take a witness statement or a long statement. It needs to be signed, read over to the accused in written form, and interpreted. What if you don't do these things? What if the police does not do these things? So for around 60 years, 60, our courts decided that the statute doesn't tell you what will happen. The statute only says these are the requirements, but the statute doesn't say what happens if you don't follow them. So our courts concluded that, oh, so if you violate the procedural requirements, whether it's 1 requirement, 2, 3, or 4, doesn't matter. Nothing will happen. Nothing will happen. So it was only in 2011, the Court of Appeal then decided that it can't be the case that nothing will happen. If the breaches are egregious enough, if they're substantial enough, and they're committed with intent. In other words, it's not just the police forgot, but the police purposely went out of the way to not record things properly, then the court can exclude the evidence. The court can exclude the evidence, and so the evidence cannot be used by the prosecution at all. But it took us a while. Next, we'll look at the other kind of statements that can be extracted from accused persons, which will be the caution statement. So this is governed by Section 23 of the Criminal Procedure Code. And unlike the long statement, unless the person has been charged with many different crimes, it will just be one statement. And unlike the long statement, you will be given a copy so that you know exactly what you're charged with. But just like the long statement, probably the lawyer wouldn't be with you, right? Because what's the test? The test is the police must be given a reasonable amount of time to complete their investigations. And I think that period tends to capture the period in which the accused has been charged. So why is a caution statement called a caution statement? Well, it's because of subsection 1 of Section 23. I'll read it out. So you have been charged with whatever crime. Do you want to say anything about the charge? If you keep quiet now about any fact or matter in your defense, and you review this only at trial, the judge may be less likely to believe you. This may have a bad effect on your case. Therefore, it may be better for you to mention such fact or matter now. So just like Section 22, this is a mixed bag in terms of presumption of innocence. Right? The caution doesn't state anything about privilege against self-incrimination in an explicit way, like Section 22, but it does so indirectly by saying that we only want you to raise matters regarding your defense now, not later. So some might say that, is this different from Section 22? Because Section 22 says you're obligated, right, to state the truth unless it incriminates you. Here, you are highly encouraged to raise anything that could help your defense later on. Some of you may then be thinking, why is it so important that the accused must raise a defense now? Earlier, I already talked about how one of the consequences is that if you change your mind, there could be adverse inference, and secondly, you're committing yourself to a higher standard of proof. But what is the real reason that this caution exists? And the real reason, according to the Singapore courts that have interpreted this provision, is that they don't want the prosecution to be caught by surprise. So if you're going to raise a defense, raise it early so that the prosecution can decide, are they going to proceed? They don't want to be surprised at trial. So this itself, I think, is not an objectionable idea, right? Because when you have a prosecution, you're using resources of the state to conduct it. Who is the prosecutor paid by? In Singapore, at least, he's paid for by the public, right? Taxpayer money. Accused, of course, he or she will have to find their own means to pay for their lawyer, but you're using court resources to prosecute. And so if there's anything that could really save everyone time, just say it. So that's the logical perspective. My counter to that is that if indeed the principle is the prosecution shouldn't be caught by surprise, then shouldn't that principle also apply to accused persons, in that the accused should also not be caught by surprise? And if that is the case, then why is it that the disclosure regime is a bit more in favor of not disclosing? The disclosure regime is a bit more in favor of the prosecution having all the evidence and the accused not necessarily having access to it, especially when it comes to the long statements, right? If you recall the long statements, the prosecution, or the police more specifically, they can obtain it as many times as possible. They can obtain it anytime. Before they charge you, after they charge you, they can keep taking statements. The more statements they gather, the greater the likelihood that there will be inconsistencies that can be used against you. So if indeed the idea is not to surprise anybody, then wouldn't that mean that the defense should also get all the statements? But we all know what the answer is, and I think everything is rationalized based on crime control. Right? If you over facilitate due process, you're going to slow things down, you're going to have less people convicted. And that's not a good thing. Right? That's not a good thing. Now, how does one justify this philosophy? Again, I go back to the idea of trust. If the public generally trusts that the prosecution and the police act in good faith, they are not maliciously prosecuting people they don't like, but really prosecuting based on the evidence, then it doesn't matter if they're given a bit more latitude. It doesn't matter if the balance is struck in favor of crime control. Right? So I think every system has to figure out what works best for them. Okay. Now, adverse inferences, I just want to say a bit more. Technically, adverse inferences are not enough by themselves to establish guilt or overcome gaps in the prosecution's case. So what then are adverse inferences for? I mentioned this earlier. The real consequence of an adverse inference is that the court is less likely to believe that a particular witness is telling the truth. So one can be very strict about it and say that, okay, yes, sure. Just because a witness is lying. So let's go back to the example of the person who has been accused of outrage or modesty on the subway or the metro. His defense essentially is accident, right? Accidentally touched the person because it's very crowded, everyone is squeezing each other, and then maybe some part of his body, touched another person's part of a person of another person, part of a body of another person. If an adverse inference is drawn against the accused in this case, is it really just going to be, I'm less likely to believe you, but that doesn't mean you're guilty? I think the consequence in all likelihood is that because there are limited witnesses or limited competing pieces of evidence, is as good as finding the person guilty, right? But it's not always going to be the case. It also depends on, of course, what the complainant's evidence is like. If the complainant's evidence is equally shaky, then the court will probably conclude that it can't be proven beyond a reasonable doubt. Where else does the idea of adverse inferences feature in the Criminal Procedure Code? So I mentioned earlier that in Singapore, you are incentivized to speak up early. And it's not just when the statements are taken. It's actually throughout the whole process. So under Section 2301 of our Criminal Procedure Code, and this is when trial has started, if the prosecution has produced sufficient evidence to the satisfaction of the court that the case should proceed. So the prosecution hasn't proven a crime yet, because to prove a crime, you need beyond a reasonable doubt. I'm talking about an earlier stage of the trial where the court is deciding, should we even continue? Does the prosecution even have enough to proceed? And if the prosecution has shown that there is enough, though not yet beyond reasonable doubt, then the court is going to turn to the accused and say, okay, look, there's some evidence against you. Are you really going to keep quiet? Or are you going to take the stand and be cross-examined? And if you refuse to take the stand, there might be adverse inferences drawn against you later on. So the idea is that at the start, when we take a Section 22 statement, we say you don't need to incriminate yourself at that point. When you are charged, they say, if you have a defense, you better raise it. Don't surprise the prosecution. Right? And then we go down the line. When the trial has started and there's a prima facie case, the court reminds again the accused, look, it's really not a good idea to keep quiet. And then we have 261 of the Criminal Procedure Code. So assuming that the accused did not raise a defense in the caution statement, but also the long statement, and raises the defense at trial, the court can say, too late, we don't believe you. It may not conclude that way. It may end up believing the accused. But the whole point of adverse inference is you're just not a credible witness. And so that's the hill that the accused needs to climb. The accused needs to show that somehow, notwithstanding, this seeming change in position, the accused can still be trusted. But that's not all. There's also Section 291. So after the accused agrees to take the stand, because he doesn't have to, right? Privilege against self-incrimination means he can't be compelled. And to be clear, he can't be compelled at any stage. So even though we have Section 230, we have Section 261, it's still up to the accused. It's just that if he really chooses to keep quiet, there will be adverse inferences. So 291 is talking about a situation whereby he has agreed to take the stand, right? He decides, fine, I'm going to take the stand. I'm going to testify. But he changes his mind. Halfway through, he says, okay, you know what? Forget it. I didn't mean it. Adverse inferences can also be drawn. So I think for 291, that's fairly universal in that you can maybe decide that you just don't want to testify. And so the court may say, you know, what's up with that? But for 230 and 261, where it's at earlier stages of the criminal proceedings, the accused is also highly encouraged in our system to testify. And if you refuse to answer questions after being put out on the stand, adverse inferences can also be drawn. So in the Criminal Procedure Code, it contemplates at least 4 ways in which adverse inferences can be drawn against you. I already answered this question, right? Adverse inferences can be drawn from long statements as well. So even though the caution in the caution statement is only read out in Section 23 and not Section 22, our courts have held that adverse inferences can be drawn from silences in long statements as well, even if the long statement was taken before the caution statement. If the long statement in question is taken after the caution statement, I suppose one could make the argument that the caution that was administered for the caution statement applies to all statements thereafter. But our courts have said that even long statements before the caution statement, right, adverse inferences can be drawn. So it seems to me that all things considered, Singapore has an extra thin conception of presumption of innocence, and that's just my view, of course, right? As mentioned, throughout the world, in the common law world, presumption of innocence doesn't have a very thick meaning. They are only concerned with who has to prove is the prosecution. Everyone agrees. To what extent? Beyond a reasonable doubt. Everyone agrees. But beyond that, in terms of how much adverse inferences can be drawn, to what extent can you deprive a defense of his counsel? To what extent can you create statutory presumptions? So on and so forth. So I think Singapore has a rather thin conception of presumption of innocence. It exists in theory, but in practice, there are many ways in which the presumption can be derogated from. So those are statements in terms of the broad requirements, right? Whether or not you follow the procedure and what are the standard of proof implications. Earlier, I had gave an example about how the police might have threatened an accused person when giving a statement. And this goes to the idea of voluntariness. Sorry, the order of this is a bit mixed up. So I'll start first with this one. 258, Section 2583 of the Criminal Procedure Code stipulates that if a statement has been made as a result of a threat, inducement, or promise, then a statement must be excluded. Threat, I think, is quite self-explanatory. Go back to the earlier example. If you refuse to give a statement or tell the truth, we will send someone to your home and do something to your family. That's a clear threat. So if assuming that can be proved, then the statement will be excluded. Inducements and promises are somewhat similar, right? You're basically trying to make the person confess to a crime. So for example, you say, okay, if you confess to this crime, we give you something in return. You know, let's say maybe there are multiple accused persons. What's the police's strategy? Divide and conquer, right? they try to make the accused persons testify against each other. And in so doing, they have to promise them something. So if you agree to incriminate the other accused, we'll give you a lighter charge. Okay, so under our CPC, you can't do that. Then there's also oppression. What's the difference between oppression and threats, inducements, and promises? Oppression has more to do with, I suppose, physical acts. So threats, inducement, and promises are usually in the form of words. Right? I threaten you with words. I promise you using words. An example of oppression might be something like you lock the accused person up in the interview room for a very long time, say for 20 hours. No food is given, no water is given. The accused needs medication and you say no. You turn down the temperature of the air conditioner to something very cool. You have the lights flicker in a way that will drive you a little crazy, right? So you're basically creating a physical environment that is trying to compel the accused to confess. So under our CPC, Criminal Procedure Code, oppression is considered the same as threat, inducement, and promise. And what that means is that for oppression, you need to show who is oppressing you. Okay? It needs to be from someone in authority. So usually that means a sergeant, a not that junior officer. And for threat, inducement, or promise, you need to show that your free will has been set. So all of these are just more specific ways of talking about the idea of whether a statement or confession has been given voluntarily. Now, in terms of the case law, even though the prosecution has to show that there's no threat, inducement, or promise, and there's no oppression, very, very, very few cases have ever succeeded in showing that there has been such a thing. So, unsurprisingly, I'm going to say that this is further evidence of a crime control model. So in Singapore, it is expected that when an accused person is interrogated by the police for the purposes of taking a statement or a confession, the accused will suffer some discomfort. We probably will not go as far as torturing the accused, but we will create discomfort. That's what the cases say. You should expect some discomfort. You're not going to a hotel for a spa treatment. You're going to a police station to give your version of the events and to make sure that you are really telling the truth, right? We got to put you under a bit of stress. We're going to put you under pressure. We're going to subject you to discomfort, but not amounting to threat, inducement, or promise or oppression. Right? Because the cases have been very consistent, very, very hard to show that such things have taken place. So which is why earlier I made the point about how a lot of this can be solved with video recordings. And the fact that we have not embraced video recordings for the great majority of crimes tells me that we still prefer the public not to be able to see how interrogations are carried out. Right? Here's another interesting thing in the Criminal Procedure Code. If let's say the person interviewing the accused misleads the accused on the law. So for example, the accused says, I want to see my lawyer. And the police says, you don't have a right to a lawyer. And that is a misrepresentation of the law, right? Because it's not that the person doesn't have a right to a lawyer. It's more the case that the person doesn't have an immediate access to the lawyer. The lawyer may come days or weeks later, but you can access your lawyer eventually. So under the Criminal Procedure Code, it clarifies that misleading the accused on the law is not a problem. Another example, imagine if the accused is a drug addict. And past a certain point, if the drug addict does not have access to his or her drugs, withdrawal symptoms would emerge, and the person will become a bit unstable, right? So in the common law system, we call this intoxication by drugs as opposed to intoxication by alcohol. And you would think that a person who is being intoxicated by drugs, whatever that he or she says, can't be that reliable anymore, can't be that voluntary anymore. But what the Criminal Procedure Code says is that that's fine. That is not going to affect the voluntariness of the statement. Having said that, a few years ago, our Court of Appeal decided that actually, notwithstanding this provision, the courts have the discretion to exclude the evidence if we think that the evidence is unreliable. So here you can see that interesting interplay between the courts and the statute, right? Because if you recall, Singapore parliamentary supremacy, which means that your written law, your statutes, have to be applied by the courts. The courts can't say we don't want to apply. And so what's happening here is that the court said, yes, we recognize that the Criminal Procedure Code says this thing, but we are going to rely on our own inherent power to say that we can still exclude evidence. So the idea of inherent power is interesting because it's really a very powerful way of bypassing statutory requirements. It's another way of saying that the courts should always have a certain amount of discretion when it comes to procedural and evidence law matters. Okay, so yeah, Section 23(4) confirms that the reading of the caution for the caution statement does not constitute a threat, inducement, or promise. Okay, I'm nearing the end, so I'll wrap up soon so that there's some time for questions. So other considerations when it comes to gathering of evidence before a trial. Statements by witnesses technically have to be independently admissible. So for instance, if you extract a long statement from a witness and the witness doesn't go to trial, doesn't testify in trial, that is a hearsay problem. Hearsay meaning that the person who originally gave the evidence cannot be cross-examined in court. And because cross-examination is very important, that's a big problem. So technically, the evidence have to be independently admissible. But there are actually cases that ignore this requirement. And to me, that's further example, further evidence of crime control. Then what happens if you have a confession from a co-accused? So I don't know if you can recall, earlier I gave an example about three friends deciding to rob somebody. Eventually, one of them commits murder. I had talked about this in the context of using common intention as a means to get them. Here, I'm approaching it from a slightly different angle. Imagine if one of the three friends confesses to the crime. He confesses, say, yes, we intended to rob, but it was another guy. It's the ringleader, right? He's the one who wanted to commit murder. So under our laws, you can use the confession of this person to incriminate the other person. And that's not extraordinary or unique to Singapore. I think in any jurisdiction, you can do that. What's a bit more unique to Singapore is that even if there is no other evidence that can show that the main accused committed murder, there does not need to be any corroboration. In other words, you can convict solely on the confession of another person if it's a confederate, right? If it's a bunch of people committing crimes. So that was the case for a long time. I think in our history for 150 years, that was the law. But that only changed 5 years ago, where they amended the statute to say that the court can choose to exclude confessions from a co-accused, right, if they think it's unreliable. So crime control, but then calibrated with a bit of due process. But since we're on confessions, another thing to note is that in Singapore, if you confess to a crime, but you change your mind later, the confession can still be used against you. Doesn't matter if you change your mind. As long as you said it before, it can be used against you. And if in giving a confession, you successfully make the case that your confession was given as a result of threat, inducement, or promise or oppression, right? The substantive requirements, the voluntariness requirements we just saw in the previous slide. But as a result of your confession, the police finds evidence that confirms your guilt. They can use such evidence. So this is in stark contrast to the American position. The American position, they have this doctrine known as fruit of the poisonous tree. So if, for instance, I go to your house as a police without a warrant and I gather evidence of your crimes, the fact that I did not get a warrant under the American system means that whatever I find in your house cannot be used against you. But Singapore doesn't have that idea, right? One illegality doesn't lead to any real consequence for other evidence. It's just maybe for the evidence itself. If you're interested, you can also take a quick look at Section 14, which is of the Criminal Procedure Code, which deals with first information reports. So this is the evidence that may be used when members of the public first report a crime. And then there's also Section 264 of the Criminal Procedure Code, which talks about how witnesses can give essentially affidavits in criminal proceedings. And for statements, I've talked about how these statements can be excluded, right? If let's say the procedural requirements are not met, if the voluntariness requirements are not met, if it's a confession from a co-accused. So these are the only known categories of illegally obtained evidence in Singapore that will be excluded. For other kinds of illegally obtained evidence, actually the law is not that clear. It seems that it's possible that the courts can still admit the evidence. So this is again quite different from any other common law jurisdictions and further evidence of crime control. Okay, so to round up everything, right, to give you the full picture and to recap, burden of proof, while technically on the prosecution, could change because of presumptions, could change because of the defenses that are raised. And likewise for standard of proof. Technically, it's beyond a reasonable doubt, but once you raise a defense, you need to prove it on a balance of probabilities. Right to counsel, as mentioned, not absolute in Singapore, not immediate. So that affects what you would say in your statements, because what you say in your statements matter, right? In terms of whether you are obligated to talk about your defenses. And if you talk about your defenses, that commits you to a higher standard of proof. If you keep quiet, there could be adverse inferences. And all of this is without any counsel advising you. Adverse inferences can be drawn at various stages. The fact that multiple statements can be taken from an accused increases the chances that there will be contradictions that will be used against the accused during cross-examination. It also means that the accused may not be able to fully anticipate what will be used against him because of limited disclosure requirements. Having said that, the court does have considerable discretion, which may not be exercised in favor of the prosecution, right? They may decide that, look, we want to have more due process, and in some cases, the courts have done that. So for next lesson, if it's the same audience, I don't know if it's the same audience, we'll be looking at other kinds of evidence that may be used against an accused person during the trial itself. So we look at topics like hearsay, similar fact, opinion, and improperly obtained evidence. For today, we're really looking at before the trial, what is the main evidence that will be gathered? It's usually the statements, right? And preferably the confessions. Okay, and if you are interested and you have the time, these are some of the other stuff I've written, which you can also take a look at if your library has access to these things, if you want to understand more about the law of evidence in Singapore in relation to criminal proceedings. So thank you very much for staying the course. We have about 10 plus minutes, I suppose, if there are any questions that I can help answer.
Thank you, Prof. Chen. Actually, our Miss Rafiqoh asked me whether is it possible for student to ask in Bahasa, but I think, as you mentioned, you are not so fluent in Bahasa. But I think it is welcome for student to speak Bahasa, then I will translate to English.
Okay. Well, I do see that there are some questions in the chat. Could I answer those questions? Do you want me to
Yes,
answer those
please,
questions?
Prof. Yes,
All right.
oh, yes, there are some already, I think. Yes, please.
Yeah, okay. So the first question relates to quality of counsel. Does that mean performance of the council is greater than written law? I won't go that far, but I would say that it's quite important, especially if it's a very complicated case. So if it's a very clear case in which the evidence shows that you have a strong case, then one or two things will happen. One, the prosecution may not proceed with the case because in Singapore, the prosecution almost never loses, right? No one really has done a study, but I think it's like 90% of the time they would win. So if they know that they're not going to win, they probably won't proceed. But of course, the other possibility is that you may then have a pretty hard time in court if they do proceed. So I think quality of counsel is indeed important, and the written law itself may not be enough. So they're all different parts of the puzzle, I suppose. Yeah, quality of counsel is, and I think also the one thing that counsel can do is that before the prosecution even begins, the counsel can write to the prosecutor to say, I don't think you have enough evidence, or I don't think that you are charging my client with the correct crime. Can you consider something else? And quite often that works. But if you don't even have a lawyer to write to the prosecutor, I mean, I suppose you can write to the prosecutor yourself, but you won't be as familiar with the process. So that's another added benefit of having counsel. So I think the short answer to your question is that all things considered, the role of the lawyer is probably more important in Singapore than in many other places. Okay, then the second question by Kennedy Koha. So the first question, is the inquisitorial system the important thing that should be added? Well, okay, so in Singapore, we for criminal cases, we still don't have that many inquisitorial elements, but we actually have that in civil cases. So in 2021, we changed our whole civil procedure regime to give the judge more power. But more power over what? More power over how to manage the case, but not yet to the extent of controlling the evidence. So evidence is still really for the parties together, right? And also the courts are still not going to interfere with how parties argue their case. So our inquisitorial system for civil cases has more to do with case management rather than fairness or the arguments that you make or the evidence that you bring. Then the second question you asked, will AI help with criminal investigation because we can make some fake evidence from AI things? Yeah, that's going to be a problem. You'll probably need experts who can tell whether something is generated by AI, and that's going to cost money. And if something costs money, who's going to pay for it? So we haven't yet reached the stage whereby there are many allegations that evidence is generated by AI. But I do think that I do think that if that day comes, the laws would catch up and something will be done about it. But my understanding of it is that it's still not impossible to tell whether something is generated by AI. There are ways in which you can try and disprove it. Then the third question you had was, how far will judges take part in the criminal investigation until a decision is made by the jury and announced by judges? Okay, so as mentioned, we don't have a jury system, right? Everything is decided by a judge. They will not take part in the criminal investigation. They may ask for further evidence, but even then they may also not ask because they are entitled to really just not participate at all. They're just sitting there, listening to the parties make their arguments, listening to the parties present their evidence, and then they decide, is there enough evidence to prove the case? Right? They don't really have to ask questions. Even though, of course, quite often they do ask questions, but they're not in the business of gathering evidence or investigating the crime. Okay, then there's a question by Anastasia. Are the judicial decisions that have become precedents collected and codified in a single document? Okay, so they are collected, but they are not put together in a single document. I suppose if one wants to understand the law of Singapore, usually people will read the textbooks by the academics, right? So the job of the academics in Singapore is to look at all the cases and rules and to structure them and explain them in a way that other people can understand. But otherwise, the courts themselves, they do not consolidate everything for you. Of course, sometimes they may write a very long judgment, which refers to all the previous cases, and one really only needs to read that long judgment because it's a very useful summary of the law, but they're not obligated to do that. Then you also asked about access to the case law. So in the past, you had to pay to access the database. Now, almost all the cases decided by the High Court and Court of Appeal. So if you recall, those are the two highest courts in Singapore, right? Court of Appeal and High Court. Those judgments will be available free to anybody in the world. I'm not sure whether it's forever, but at least when they are first released, they are free for quite a long time. So you can Google them. If the judgment has been released in the past 2, 3, 4 years, usually they will be online for free for a long time. But if it's before that, it may be harder. Okay, then there's a question by Jonathan. How long it takes to proceed with one criminal case in Singapore? It depends on the crime. So if crime control is one of our mantras, one of our philosophies, the other main philosophy we have is speed. We like things to be efficient, but it still depends on the crime. I think if it's quite a straightforward crime, less than a year is possible, maybe a few months, if not slightly more than a year. But if it's a very complex crime and a very serious crime, say it's murder, rape, trafficking drugs, you're looking at least 2, 3 years, right? Because you also need to take into account that there could be a lot of things that happen in between, especially if the parties want to appeal or if they find new evidence. So main factor is how complicated is the crime, how serious is the crime. The less serious and less complicated, the faster it can be dealt with. The more complicated and more serious, you're looking at 2, 3, 4 years. Yeah, so those are all the questions in the chat. I wonder if there are any further questions from the audience.
Hello, Bu Rafiqoh. Prof, we have a problem with the connection right now.
Oh, okay.
Yeah, I am in a different building actually with the students.
Okay.
I'm still Prof, you at the last slide, you asked the student to read 1 to 4 for journal that you write.
Yeah.
Can we access?
Yeah, for the journal article, I can send it. For the other ones, there are books which, I mean, the students don't have to read. It's only if they ever need to research on Singapore law, that's a possible starting point. But
I think
I can.
I mean that Bu Rafiqoh will ask them to read it. So I'm trying to access it.
Sure, I can send over I can email you the article.
Are they all the open?
For the article, it's open access, but not the books. But I think it's not critical to read the books. You can just read the article if you want to find out more about the topic.
So in the next class, they will discuss with you.
Okay. Well, I noticed there's another question by Karina in the chat. So the question is, other than the courts or the police in Singapore, is there an institution who have the rights or competence to help investigating a crime case? Okay, so the short answer is kind of yes, but not in the same way. So what do I mean by that? So we have the police that investigates most crimes. Then we have the CNB, which investigates crimes relating to drugs. So the CNB stands for Central Narcotics Bureau. We have the CPIB, which investigates corruption. So these are the three main bodies that investigate crimes. We also have the Commercial Affairs Department, which investigate commercial crimes. But if the question is about, is there, for example, an ombudsman? We don't. So it's really just the Attorney General's chambers, which will be the Public Prosecutor's Office, working together with the different police agencies that I mentioned.
Yes, yes. Okay, so I think it's very hard for us to have the good connection right now.
Okay.
Okay, so I think I will tell the student.
Yep.
Do you have like us also?
I'm sorry, I didn't catch the last part.
I mean that so you also have a corruption. I mean that the anti-corruption institution like Indonesia in Singapore.
Yes.
Okay.
Yes.
Okay. I have contact Ibu Rafiqoh, and I think they still have a problem. They said that it's some finish at 9:10. So I think it's better for us to close the class. Then we will, Prof.
Okay.
Would you like to make a closing, some words for closing, sir? Prof?
Okay. Well, no. Other than just thank you very much for listening. If you do have any questions, I suppose I'm happy to answer them over email. Because to me, nothing makes me happier than curious students. So I'm happy to answer any questions that any one of you might have. Because that's what email can do. So thank you very much.
Thank you very much, Prof. Chen Siyuan. I have informed to the student your email. Then if they have a question, they will discuss with you through the email.
All right.
Okay.
See everyone next week.
Yes, thank you. Thank you, Prof. And see you next week.
Thank you.
Thank you, Prof.
Welcome. Thank you very much.
Yeah.
Bye-bye.
Bu Rafiqoh, kelasnya udah ditutup.
Udah mulai putus-putus kami di sini. Jaringannya makin parah. Terima kasih ya, Bu Rosmalinda ya. Mudah-mudahan yang minggu depan lebih lancar.
Ya, nanti diinform aja ke Wadek 3, Bu, terkait.
Saya pakai dua
Kayaknya
ini,
ini.
satu nggak pakai edorum, putus-putus juga.
Baik-baik, Bu.
Benar kami. Oke. Makasih ya Bu Rosmalinda. Udah kan?
Iya, putus-putus.
Udah pas diskusinya putus-putus pula. Thank you.